Come on, 2, 3.
Good morning. Welcome back to the Broadcast Retirement Network. I'm Jeff Snyder. This is BRN AM for Wednesday, May 11th, 2022. And our top story today, legal considerations for fiduciaries when sharing employee information for benefit plans. Joining me now to discuss this and a lot more are Elizabeth Goldberg of the law firm Morgan Lewis and Kevin Walsh from Groom Law Group. Kevin, Liz, thanks so much for joining us on the program this morning.
Thanks for having us on, Jeff. It's always great to appear on your on video and on screen. So thanks for having us on.
Yeah. Well, and Liz, great to see you. Great to meet you. You know, we did a show a couple weeks ago with Tim Rouse of Spark and Jamie McInnes of Oculus Partners talking about the importance of data and data sharing. And it really serves an important role in terms of record keeping and providing participants with important outcomes. But Liz, I want to start with you, and I want to get the legal perspective. I know there's a lot of legal pieces to this, the role of the fiduciary, what's privacy and whatnot, but how are you and the folks at Morgan Lewis breaking this all down?
Well, I think when we're talking about data sharing, and is that what we're focusing on right now, data sharing?
Yes.
Yeah. I think when we're talking about data sharing, first you sort of need to figure out the landscape of who is implicated in the data sharing and in what capacity. Because, I'm an ERISA attorney. So the first thing I need to figure out is, does ERISA apply to the use of the data? And if so, in what capacity do different vendors have possibly duties under ERISA? So I'm always trying to figure out, how does this data relate to the different parties that want to use it?
Kevin, this is a topic that is being addressed at both the federal level and the state level in terms of privacy. But you and Liz both presumably review a lot of contracts. There's a lot of data that goes between the record keeper, the employer, the advisor, the participant. How do you see it all shaping out?
So, I think Liz is asking a lot of the right questions. And in terms of when I think about contracts or I think about what's going on, it's important to recognize we're in an unsettled landscape with respect to data. Europe acted first. We have California with CCPA and now CPRA. And in terms of what do you want to have in your contract, what do you want to share with your vendors, what do you want them sharing? I think it's important to think that, it's important you're able to provide benefits. So, your vendors are going to ask for access to information. And if you say no way, no how, you're going to put them in an awkward spot. On the other hand, if you don't understand how that data is being used, then, how do you make responsible decisions? So, right now, it's a little bit of fluidity in terms of what you do and how you contract with vendors. But, when I was testifying in California last week on their CPRA regs, one thing that was highlighted is the need to, future-proof law so that, innovative new benefits like student loan repayment don't end up outside the scope or don't end up, falling by the wayside as folks try to, limit the use or conform with, perceived use of data.
Yeah. Liz, I want to come back to you, and I am a reformed record keeper, and I have lived through the removal of the Social Security number from the participant statement, or I'm kind of dating myself here, but that is a key indicator for so many aspects of the retirement system, but yet privacy, so important. Let me ask you, in your conversations with clients, because you're working with all different types of entities that sponsor retirement plans, is privacy top of mind for many employers, many plan sponsors?
Yeah, it is, for a couple of reasons. So first of all, I know we're talking about privacy, but privacy dovetails with cybersecurity. And our primary regulator, the Department of Labor, recently came out with a whole set of cybersecurity guidance. And so right away, that's making it top of mind for both vendors and plan sponsors, plans. Privacy is sort of a different animal, but it is also top of mind, one, because as Kevin mentioned, we have a bunch of activity in a number of different legal regimes teeing up privacy issues. We also have litigation already in the ERISA space regarding privacy and data usage, and questions regarding whether plan sponsors have a responsibility to be proactive in protecting the privacy of their employee/participants' data. So yes, absolutely, this is a top of mind issue.
And Kevin, I have to think that this is an issue, if it's top of mind for the fiduciary, and I think Liz does a great job in breaking it out. It's not just privacy, it's cybersecurity, it's really overall protection. Vendors have a responsibility, maybe not responsibility, but they are really focused on how do they balance delivering participant services, which they often are contracted for, but getting information and making sure that that information doesn't fall in nefarious hands, because you want to avoid that at all costs.
Nefarious hands, Jeff, that's a great way to say it. I think there's a lot more alignment on cybersecurity where participants, plan sponsors, plan fiduciaries, and vendors all like to think that more secure data is better. On the topic of privacy, I think there's kind of some incoherence at the moment where participants want and expect innovative new benefits. But on the other hand, if you ask them in the abstract, do they want more privacy? They generally say they want more privacy. So I think that's an area where, privacy in terms of what service providers do, what plan sponsors do, and what participants want, I think there's some, dissonance. I don't want you to know my student loan balance, Jeff, as my employer. But if you offered to repay some of my student loans, or if you were considering designing a program that was going to do that, you would need that information. So I may want that program to be in place while at the same time being uncomfortable, much like I may not want you to know where I live if I leave the company, but I still want to get my pension check.
Right, that's true, Kevin, and I know you're a big advocate for missing participants. That's important if you want to make sure you're getting your statements and you know where your money is. So I guess there's a lot of different pieces to this that people have to put together. Let me ask you this before we go to commercial break, guys. I know Department of Labor, the Employee Benefit Security Administration is just one of the regulatory bodies, but is that the only body that has oversight of data, or is it Internal Revenue Service, which has compliance and reporting requirements? Kevin, I'll start with you, and then I'll ask Liz the same question.
Yeah, I mean, I'm not totally sure that the Department of Labor really is the primary regulator of data, or even a primary regulator of data. If I look at data use, I see that the Federal Trade Commission is very active, and that Congress is considering giving it expanded powers there. If I look at Gramm-Leach-Bliley, which is an existing privacy law, you see that the SEC and OCC, and even the Federal Reserve has some oversight functions there. So I think we need to be mindful that in our benefits world, we like to think of the Department of Labor as the be-all and end-all, but on the privacy front, they regulate pensions. I'm not sure if they really regulate, personhood and identity.
Yeah. And Liz, there's a real expertise here in managing data. Same question to you. Is it do you share the same perspective as Kevin that maybe DOL isn't the only arbiter of what is private or not private?
Yeah, so I would say that the DOL is the arbiter within a very narrow realm of sort of fiduciary protection with respect to these issues. So, maybe another legal regime is primary, but as a fiduciary, do you have any sort of duty to understand that legal regime or how you interface with it? I think Kevin does a very nice job of identifying some of the other potential regimes, and I would agree with him. Once you go beyond ERISA's fiduciary duties, the DOL is not the primary or the be-all end-all. Here's what I would note. Preemption is going to have to sort some of this out, because preemption in ERISA, the concept that ERISA trumps other legal regimes when you're talking about the disbursement of benefits. I think there are some legal questions that need to be sorted out to determine sort of what legal regimes are primary.
It's certainly not a 0-1 perspective, and I completely agree, and that's why we have you two great I'm going to call you legal scholars in the room. I need to take a very quick break. When we come back, we'll talk more about managing data, privacy, but delivering participant outcomes. We'll talk about it from the legal perspective. You're going to want to stay tuned right here on BRN AM. Imagine a new television network that will make you richer, healthier, and in control of your financial future. This network is for the policewoman in Nashville, Tennessee, the baker in Dubuque, Iowa, the teacher in Lexington, Kentucky. We want to make the idea of savings and retirement culturally relevant. But what do you see as a defining issue of the midterms? Especially for the smaller businesses. I mean, they are the lifeblood of the American economy. Featuring exclusive interviews, current affairs, and docuseries. 33 years old, you retired early.
The philosophy is money only matters if it helps you live a life that you love.
But you got to start thinking about retirement as soon as you get in.
The Broadcast Retirement Network will drive very high engagement with premium partnerships. So this isn't retirement and savings for your parents or grandparents. This is for all Americans. And we're going to change the way you think about money. Welcome to the next frontier of retirement and savings. This is BRN, the Broadcast Retirement Network.
Are you stuck with a low credit score? A credit report and score that's causing you to be denied credit or pay higher interest rates than others for the same things? Then do what Terrence did and call Credit Repaired for your free credit evaluation to help restore your credit.
I started thinking about buying a new house, and my score wasn't where I needed it to be. I called and spoke with one of the representatives, and we just had a good conversation, and I liked what he was saying.
Just one call for his free credit evaluation was all it took to start back on the track to repairing his credit.
I'm seeing the deletions and I'm getting the report, so I know something's being done. It does make a difference to me.
All it takes is one call to get started.
Credit Repair has given me a second chance to have a better credit score.
Don't let a low credit score hold you back another day. Do what Terrence did and make the call for your free credit evaluation.
Call 800-819-4152. That's 800-819-4152. Again, 800-819-4152.
Welcome back. We're talking this morning to Elizabeth Goldberg of Morgan Lewis and Kevin Walsh of Groom Law Group. Liz, Kevin, thanks for staying with us this morning.
Yeah, happy to be here.
Yeah, I'm so glad I didn't chase anybody off, but this is a really important topic from a lot of different perspectives. Liz, I want to come to you because litigation is never far from a plan sponsor's mind. Not that they want to get sued, but they want to make sure that they're documenting, doing the right things. Has litigation evolved to take into account data sharing, and privacy?
Yeah, no, it has. And you've hit the nail on the head. One of the things I always say about ERISA is that we have a very active, very entrepreneurial plaintiffs bar. And they are looking for new theories. They're looking new ways to slice an apple and bring lawsuits. At the same time, you know, as we talked about earlier this morning, there's some real risks, some real concern in this area because people care about cybersecurity, people care about privacy. So we are seeing cases filed on these issues around data usage, privacy related to ERISA plans.
And Kevin, go ahead, Liz. I apologize. I cut you off. Go ahead.
No, I was going to say, would you like me to tell you about the cases, or should we turn it over to Kevin to do that?
Well, I think let me go back to Kevin real quick, then I'll come back to you. Kevin, evolution here, and Liz makes a really good point. The plaintiffs bar, boy, they are entrepreneurial and they can come up with some interesting cases, and there's been an evolution there. But also it's a balancing act again of providing data, helping participants. How do you and the folks at Groom see it?
Yeah, and I think Liz put me on the spot with the throw to me for talking about some of these cases was a pleasant surprise in some ways. I mean, I look at it, and I think there's got to be a balance between, there's a tension between litigation risk and designing innovative new benefits. I think that in ERISA, we want to get more people to a secure retirement, but in order to do that, we need to have our benefit plans evolve with the times. And in the early cases we've seen about the use of data, so Harmon v. Shell is one in Texas, and then There's a Northwestern case at the district court level that talked about privacy. It went to the Supreme Court on other grounds. It's back on other grounds. So really the two initial privacy decisions we've seen have been favorable in terms of saying, plan sponsors, we understand you're afraid of this. Litigation is going to continue. But for now, we're not going to say that, you're allowing record keepers to help design innovative products using participant information or using information related to your plan is a bad thing. So I think we're going to continue watching as this evolves. The decisions have also been different than the settlements. And in some cases, we've seen some settlements that limit the ability of plan sponsors to use data. So it's concerning because there is this tension where, we want innovative new benefits. As I said, student loan repayment would be awesome. I'd support that because I've got too much in student loans still. But, if folks are going to be scared that needing more information is a bad thing, then I think we're going to see some stagnation in the benefit.
Yeah, and Liz, Kevin makes a great point. If you don't want to have stagnation because the whole purpose, this is a really important time for Americans. We're seeing Americans retire now with the defined contribution plan as the primary benefit. There's a real need to guide people. And I use the word guide, I'm not saying you got to direct people where they need to invest or not invest, but there's things like annuities and rolling money out. You need to be able to assess somebody based on their individual factors. This is important. And so to face litigation or potential of litigation, you don't want to unwind some of those important aspects of service.
Yeah, and I think that's a tension that, I'll take it from the plan sponsor perspective, they are dealing with, because there is, as Kevin's articulated and you articulated, a lot of potential benefits to data usage for participants, a lot of ways to help them pre-retirement and retirement. At the same time, one of the theories underlying these cases has been that this usage of data is something of value, and the plan sponsors sort of need to understand what that thing of value is, whether it has a monetary value, and if it does, are they sort of understanding how it's being used? And I can't say that notion is necessarily inconsistent with ERISA's broader concept. So there's a real tension here, and the courts are going to have to sort it out as to, we know this data is good, but at the same time, we want to make sure there's some understanding and how it's being used.
Liz, let me ask you, in terms of, I've done a number of RFPs and vendor searches, but you really have to get into the weeds here during the evaluation process of the vendor, the contractor, the service provider. But you've got it sounds to me, and I don't want to put words in your mouth, so I'm going to ask you to clarify. It sounds to me that this is an ongoing conversation with the vendor. It's not a finite, hey, we selected vendor ABC, we evaluated them and how they're using data, and then, okay, it's good for the term of the contract. It sounds to me like it's a continuous conversation that has to happen because these vendors are rolling out new tools all the time.
So I'm going to give you a very lawyerly answer and say I think it depends. It depends on the facts, the vendor, the contract, But yeah, it's probably not a one-time thing, and it's probably going to continue to evolve. I would agree with that.
Yeah, Kevin, go ahead.
I'm going to steal Liz's takeaway because she's hinted at her takeaway a couple times, but I don't think she's come out and said it. So I want to just steal her thunder a little bit. Yeah, if I'm a plan sponsor, if I'm a plan fiduciary, one thing that I want to do is I want to understand what data my service providers are collecting and need, and I'd like to understand how they're using it. Not every plan fiduciary, not every plan sponsor is doing this, but to me that seems a helpful step in terms of future-proofing your operations around an.
Yep. Oh, I think it cut out a second there, Kevin. I don't want to. You were going to steal Liz's thunder. What's the last piece you were going to say?
Oh, stealing Liz's thunder. Yeah, I think that if I think about what I see plan sponsors and plan fiduciaries do, is many of them are being proactive in terms of asking service providers about what data they're collecting and how they're using it, because that helps position the plan sponsor, plan fiduciary best in terms of understanding what risks they're facing, what's going on, particularly as we have an evolving privacy regulatory landscape.
Yeah, it is. It's so amazing tackling some of these newer technological challenges, and they're, things are rolling out, brand new services. I guess my last question for both of you, and I remember the investment policy. I've read the education policy. Could you ever see a time, and I'm not wishing this to have more policies, where there is a privacy or data management policy, or does this just get baked into the contracts or the service provider contracts? Start with you, Liz.
Well, here's what I'll say. So I spend a lot of my time helping clients with Department of Labor investigations, and the Department of Labor has a cybersecurity initiative right now. And one of the things they are asking for are, can we see plan a copy of your cybersecurity policy? I haven't seen it yet worded as a privacy policy, but the bottom line is, apparently, there's some questioning from the DOL that suggests that they think there should be policies. As a practical matter, do I see plans evolving that way? I'm kind of with you that I think a lot of it is driven by the contract, because a lot of it's driven by what the vendor does. So
Yeah.
I guess the final answer is I would say not. I don't think the answer is never. I think it's a possibility.
Yeah, Kevin, I want to come to you to finish out the segment. Your thoughts on that and get your perspective.
Yeah, I could see some privacy policies evolving over time. On the other hand, if I look at different parts of the market, really some of the vendors have more leverage than the plan sponsors or plan fiduciaries. So I would worry if a smaller plan or a mid-sized plan wants to rush ahead and adopt a restrictive policy, that they may find they can't get services for their plan, and that to me is a worse outcome than having to look at each privacy decision in an ad hoc manner.
Yeah, really important.
Really
Well,
good point.
Liz, Kevin, great to have you on the program. Thanks so much. I have a feeling we're going to be talking about this one for quite some time. Great to see you. Thanks for joining us, and we look forward to having you both on the program again very soon.
Thank you.
Thanks, Jeff. Yeah, this is an issue that's just taking flight.
That wraps up this episode of BRN AM. Have a topic of interest, somebody you think we should talk to, drop us a line. And don't forget, for all the latest curated news and lifestyle, wellness, finance, tech, so much more all in one place, check out today's edition of our daily newsletter, The Morning Pulse. Want to search our archives, check out our latest content? We'll visit our website and our streaming partners like Amazon, Roku, Samsung. There's over 100 to choose from. We're back again tomorrow for another edition of BRN AM. Until then, I'm Jeff Snyder. Stay safe, keep on saving, and don't forget, roll with the changes.
Waiting here for you to take and drink of. But if you're tired,
Now is your opportunity to co-create content around any topic on the First Lifestyle and Wellness Network. Reach a global audience through our platform and co-own exclusive branded content. All of our programs are available on demand and also as audio-only podcasts, so you can take us on the go. Broadcast Retirement Network, available anytime, anywhere, and on any device.
Are you being audited and do you owe the IRS $10,000 or more in back taxes? Is the IRS threatening to take more of your money? Don't fight the IRS alone. The Tax Doctor is here to help you negotiate your tax bill and reduce your stress. The IRS can freeze your assets and seize your bank accounts, but you can stop these IRS actions. The Tax Doctor will work with you using our years of experience to represent your case to help you get the best resolution under the IRS guidelines. Help is here to deal with the IRS to reduce your stress. We've handled thousands of cases, so we know what we're doing. If you owe $10,000 or more in back taxes, do not call the IRS alone. Call a Tax Doctor now for a tax emergency analysis.
Call 800-224-6439.